Thank you so much. It's a real pleasure to be talking to you today about legal liability for insecure software. Write once, cause damage anywhere. The thing is, with writing software, as you know better than me, it replicates. You don't write it to, at least in many cases, to install it in one machine, have it run once, but have it run with different customers, maybe release it to general open market, have it installed on thousands, millions of machines. But what if something goes wrong? This is what we want to talk about today. The legal liability of the company publishing the software on the market, to some extent issues of personal liability of the person actually coding it might come up. For me, it would be simply most exciting if this would not only be a one-way discussion here, so that I'm not only presenting what I brought, but really I'm most curious to hear the questions that you have. So I will leave plenty of room to really discuss what is on your mind. And please do not hesitate to interrupt at any time by raising your hand to ask a question that you feel is relevant at any time during the presentation. All right, what we want to talk about is first, what kind of vulnerabilities actually pose a legal problem? Are there certain vulnerabilities that are perfectly fine, that from a legal perspective are no issue to begin with? Or on the other hand, does the law expect us to produce perfect software? Secondly, we want to look at a bit the difference between off-the-shelf software and custom software developments, from the developer perspective as well as from the customer perspective. There are cases, even when you're working in software development, that you will find yourself in the customer perspective, in the sense that you're licensing third-party software to then use in your projects and accordingly ship out to the customer. So in any case, the customer perspective is something that we have to keep in mind, because sometimes we will be a customer ourselves, and sometimes simply because it's valuable to better understand the perspective of the people you're providing your code to, from a legal perspective, that is. Then we want to look at what is really a very significant technological and market trend, and that is the move towards software as a service. Quite clearly, from a technical perspective, different things are happening here than with a desktop application, but this technical change has also very significant legal implications that we want to look at closely. And last but not least, I want to talk a little bit about what software litigation looks like in practice. There is a lot of, let's say, risk mitigation we can do up until a litigation, where we can ask ourselves, okay, what kind of risks do we have? How do we want to manage them, contractually or otherwise? But when push comes to shove, we're sitting in front of a judge. And what happens then? The practical implications of going through a litigation, something I want to talk about, simply to give you a bit of an idea what is really relevant at the end of the day when we have to fight this through. Okay, starting off with the question, are there vulnerabilities that are acceptable? Are there certain mistakes, if you will, that we're allowed to make? Here we have to, from a legal perspective, differentiate a little bit between two worlds. And that is cases where we are providing our software to consumers, that is B2C, business to consumer transactions, or where we're providing our software to other businesses, B2B, business to business. Here the law differentiates simply because the law aims to protect consumers in their economic dealings. And we have indeed a new EU directive that will be implemented in all EU member states until 2022, that specifically and for the first time in the European Union regulates the liability of software vendors. For the first time, we have specific legislation addressing what somebody providing digital goods in general, but quite specifically also software has. And the directive tells us that as a developer, as strictly speaking, as the company entering into a contract with a consumer concerning the delivery of any kind of software, we are liable basically for two things. One, a certain quality of our software, and that quality has to be whatever we have agreed with the consumer, quite clearly. If we come to a certain agreement that the quality of the software has to be X, let's say, not contain any severe security vulnerabilities. I would never put that in a contract if I was writing the contract for a developer, but let's say it says that in a contract. Well, then that's it. Then that's our standard for liability. Or if we have not agreed anything, if the contract doesn't say anything about what kind of level of security the software will provide, well, then it's the usual quality of a software we have to provide. What's the usual level of quality of a particular software of the same kind, the directive says? Well, that's anybody's guess. We could, of course, look at large commercial products, see how many vulnerabilities were discovered in these products over the years, what kind of severity these vulnerabilities had, and then come to some kind of conclusion. But still, it's a very vague determination we would have to do here. So the first learning I would take away from this is, do put something into your agreements how secure your software will be. I know it might be easier to say nothing and not raise the issue, not to get the customer thinking about security stuff. But at the end of the day, from a legal perspective, it pays off to be explicit here, to really say, what will you be delivering here? And if in doubt, don't show off in a contract. If in doubt, undersell. Act as if you would be producing horrible quality in terms of software security, because ideally that's the liability standard that you would have. A standard that you can meet in your sleep. Ideally, of course. In the real world, the market forces might make it necessary for you to promise to deliver higher quality. Well, if you do, then make sure you actually have processes in place that deliver such results. Secondly, the directive says the software that we're delivering to a consumer has to be fit for either the purposes that the customer communicated prior to concluding the contract, or, if no such purposes were communicated, the usual purposes. What we can take away here is, be careful if your customers tell you stuff. Oh, I want to use the software for this, for that. Make sure you can actually produce software that is fit for that purpose. If your software is only meant to be run in a secure environment behind 3 firewalls, and the customer is telling you, oh yeah, by the way, this will be installing on our machine outside the demilitarized zone, because we want to make this usable for everyone and stuff. Well, be careful and don't just simply ignore what they're saying and kind of, oh yeah, that's their problem, but really think, is this something that we have built our software for? And if not, tell them. In effect, make sure you reach an agreement that this software is not fit to be used in an open network environment, for example. These are liability issues vis-a-vis consumers, of course. So for certain types of software, yes, this is directly relevant. One exception is particularly valuable here that the directive provides, and that is this liability regime does not apply for open source software that is provided without the customer having to pay for it. So for open source software, there is no statutory liability regime vis-a-vis consumers. And that's good news, really. If you're developing open source software, this is basically something you do for fun, I would hope. Companies, of course, have certain economic motivations behind it as well to get a certain market reputation, for example. But nonetheless, if it's for free, you don't want any liability, and the law says, that's fine. You don't have to take on any liability. The big difference when we look at the B2B side, where we are engaging with businesses, is that there isn't much statutory law at all. As a matter of fact, this is mostly regulated by contract law in each EU member state or any other country in the world. And basically what it comes down to is whatever we agree to counts. So you really have to make sure that you have agreements in place that are in your favor. If you don't have any kind of agreement, but nonetheless money is changing hands, that is a very uncomfortable situation, because at the end of the day, a judge will start asking a kind of theoretical legal question. What would reasonable parties have agreed to? And you don't want to know the answer to that. What a judge thinks that is reasonable is not what you would want to see in your contracts. So putting something down in writing, making sure you're not taking on more liability, you're not promising more than you can deliver is key at that point. When we look at thresholds like average or usual quality, what is a usual quality? Well, if we look at the real world, I think we clearly see zero vulnerabilities is not usual. Any software has vulnerabilities. Maybe the software hasn't been looked at closely enough yet and nobody has found any, but you can certainly bet your house any piece of code that is longer than a couple of lines has vulnerabilities in it. Of course it does. So perfect software is, at the end of the day, not what the law is asking us to produce. I'm not 100% sure that all judges will understand that right away, which what I said before remains to put it down in writing. But looked at the end of the day, perfection is not what the law is asking us for. However, if you're simply using, let's say, a monolithic architecture for your huge piece of software, you have huge fluctuation in your software development team, no 4 I's principles, no code review, no coding standards whatsoever. The people have rather little coding experience and have received no training on secure coding. Well, you can bet, again, your company, that you will produce countless vulnerabilities that will have each of them most likely quite significant impact, since you have implemented a monolithic architecture. Let's say, historic good example, send mail. Building one monolith is probably not the best way to go here. So if you're simply producing a huge lot of vulnerabilities, that fact alone will likely mean that you have not delivered usual quality. And here a contractual agreement that simply says, no, we'll be delivering below usual quality, yeah, would help you, but hurt you significantly when you're trying to sell your product. So try aiming for average, I'd say is a good thing. There is one particular type of vulnerability that will get you in trouble no matter what your contract says, and that is backdoors. If you're unlucky enough to be shipping a product that contains a backdoor, no contract will save you. At the end of the day, most judges would simply say, are you crazy? You can't disclaim liability in a contract for shipping a product that contains an intentional backdoor. As I'm sure all of you know, these things are, in very rare cases, strategic decisions by the head of the development team to, let's put a backdoor in our product, but rather simply something that stays in there because a crazy developer didn't quite think this through and thought it would be a good idea during the testing process or whatever, put a backdoor in so that he or she can circumvent the usual way of using the software. Simply not having to create a new account and then log in via that account in order to test a simple feature. How about we put a backdoor in? Could be as simple as a hard-coded password. I do remember one of the first things that I wrote some 15 years back. It was an online game for, I think it was T-Mobile back then. It didn't ship with the backdoor, but of course, during the development process, one of my first projects, I thought, oh yeah, wouldn't it be nice if we had some hard-coded password in there so everybody can during the testing, can easily get access, and we did that. Of course, we took it out before shipping the product, but we easily might have forgotten to take it out, and there lies the problem. So the practical suggestion here is don't put any backdoors in the products, even during the development stage, period. Don't. And if you really feel it's absolutely necessary, make sure you have some kind of exception process in place that the backdoor gets documented, and then you can make sure that you take it out before shipping it. But otherwise, you're looking at a vulnerability that really, really hurts. We've seen this countless times for even things where it's rather difficult to update the software. Many kinds of appliances, even in the network area, kind of many types of routers or other network appliances containing hard-coded passwords. It's the kind of crazy thing that nobody will be able to help you if you find yourself in that position. Average usual quality is also kind of, how severe can the vulnerability be? Certain common coding errors, they might have a significant impact, but nonetheless, there will be certain vulnerabilities if an expert witness looks at them, would say, oh, come on, really? You have been storing the private key unencrypted somewhere on the hard drive? Come on. Or you have been, there was an incident like that concerning the German implementation of the electronic systems that courts and attorneys use to communicate with each other. They ultimately managed to compromise a private key by, well, more or less keeping it unprotected. And that impacted the entire system, the entire Republic of Germany. The system the courts and attorneys were set to use to communicate with each other was compromised that way. That's not average quality. That's below average, I'm afraid. So there are certain kind of things where having good software development processes simply pays off a great deal. Protecting yourselves against certain things in your contracts, yeah, it's a possibility. But some things, even the lawyers can't help you there anymore. More specifically, if we look at, well, what should we be putting in our contract? What are the things that customers, if they're negotiating a contract with you, might ask you to promise in your contract? Or if you find yourselves negotiating a contract with another software developer so that you are on the receiving end, you are their customer, and what would you want to negotiate into these contracts? Well, what is, quite frankly, it's not happening that often because most lawyers negotiating software contracts don't have that much experience in the security field. What I would expect if you have somebody who knows their stuff on the other side is that they will demand reference to, let's say, for example, the OWASP top 10 critical web application security risks if you're delivering some kind of app application. Those of you that have looked at the top 10 know this is a broad category. Many kind of things fall under the top 10. Any kind of authentication weakness falls under the top 10. All kinds of cross-site scripting, you will find in the top 10. So if you're promising to not ship products, specifically a web application, that contains any of the OWASP top 10, well, then you have to deliver more than average quality. You have to deliver a really reasonably secure piece of software. On the other hand, if you're negotiating with a software developing company and are able to negotiate this in, you're on pretty good grounds. You have a very decent contract in your hands. Same goes more generally for the CWE top 25, most dangerous software errors. If you ever looked at these top 25, well, it's not only the most severe, the most dangerous kinds of software errors, it's also the most common ones. And that's really, if you get that into a contract from a customer's perspective, you have a very long lever in your hand. If something goes wrong in the development process, if they manage to put a vulnerability in there, most likely it will be on the top 25 list, and this will be a clear breach of contract, entitling the customer to claim full damages, etc., etc. So, from a customer's perspective, managing to negotiate these in, a reference to these top 10, top 25 lists, great success in the negotiation. If you find yourselves in the position of having to promise to deliver that, well, you better buckle up. Another way, something that is not that often done in practice, I've seen it twice though, is including a more general reference to the common vulnerability scoring scheme, a scoring system, saying that the software may not contain any vulnerabilities that have a base score higher than X. The reason that I don't think that this is very practical is that the base score itself is not very meaningful. In many kind of deployments, you will have very different security requirements, and only the custom calculated score is actually what is valuable to the customer. The base score itself. But nonetheless, you might find that. In that case, the common vulnerability scoring system provides methodologies for how vulnerabilities are scored, how severe the vulnerability is considered to be. And for basically all, or at least most vulnerabilities that receive a CVE number, there is a score being assigned by, I suppose, guys working at the National Institutes for Standards and Technology that are operating the National Vulnerabilities Database on behalf of the US Department of Homeland Security. So you have a third party for large software products assigning that base score. That has a certain guarantee of accuracy, if you will, or objectivity at least. As I said, nonetheless, it's from a customer's perspective, probably not that valuable. Another thing that, from a customer's perspective, you would want to put into a contract, and from a developer's perspective, you should be prepared that it gets negotiated into your contract, is basically an obligation to not ship third-party software that contains known vulnerabilities. Kind of makes sense if you're using some open source library and you're using an outdated version of it that contains known vulnerabilities and shipping that to the customer that some liability is attached here. Yeah, makes kind of sense. From a customer's perspective, negotiating this in is very valuable because otherwise you can discuss at length whether or not the developer should have known, should have checked, what level of diligence should have been performed, etc., etc. So be prepared that this is in a contract. And therefore, any kind of third-party tools that you use, quite obviously, and I would hope most companies already have such processes in place, you're monitoring the vulnerabilities of such software. If it's smaller software products, simply subscribing to the announced mailing list, security mailing list, seeing what comes up there, in addition to, of course, subscribing to the more general vulnerability disclosure mailing list. Or, alternatively, to all of the above, how about disclaiming any and all warranty and any liability for our product, not promising to deliver any software fit for any particular purpose, basically saying we're not responsible for anything. how can we put this into a contract? Wouldn't that be nice to have in a contract? Yeah, it would. The problem, though, is that in continental Europe, at least, in the civil law jurisdictions where we have a certain legal tradition that doesn't allow people, or companies for that matter, to freely agree on anything, but rather restrains the freedom to contract, such a provision would not fly. In particular, in types of contracts that are used for many customers, in general terms and conditions that are not individually negotiated between two parties, practically all countries in continental Europe have very strict regimes, Germany being among the strictest, that basically make it impossible to include such a broad disclaimer of responsibility into a contract. In particular, as an Austrian company, concluding any kind of software development agreement with another Austrian company, putting this into a contract will not work. It will not withstand the scrutiny of the judge. It will at least partly be considered void, not validly agreed. How come, though, that in practice we very often see these kinds of broad disclaimers in license agreements? Well, because they are not continental European agreements. The choice of law clause that you would find in these agreements that basically says this agreement is subject to a particular country's laws will typically direct elsewhere. For example, to the United States and let's say the state of California. Under California contract law, you can basically agree to anything. There is no limitation there whatsoever. You don't have to go that far. Even Irish law allows you a lot more leeway as a software developer, as a licensor, to disclaim liability. So how do I get to Irish contract law? How can I make Irish contract law work for me as a developer? Well, the bad news here is you have to be established in Ireland, or at least in some other country than your customer in order to choose Irish law. And the reason for that is that under that's EU-wide the same rules, and in EU regulation, so-called Rome I regulation, says that if two contracting parties are established in the same country, they cannot disclaim the mandatory law of that country. So as an Austrian company contracting with another Austrian company, you are stuck with Austrian law. If you're contracting with a German company, on the other hand, you are free to choose Irish law, for example. And that's what many of the large international software vendors are doing. They, of course, for other reasons too, have an establishment in Ireland and make all their license agreements subject to Irish law, which gives them a whole lot more flexibility. If you will, that is a bit of a competitive advantage for an international software vendor, as opposed to a software vendor that does only local business within its own country. I'm not quite sure that is totally fair, but that's the way the rules are. So doing business internationally gives you more flexibility from a vendor perspective and allows you to get broad disclaimers into your contract that you otherwise wouldn't be able to. Now let's talk a little bit about off-the-shelf software versus custom developments. For off-the-shelf software, disclaiming any and all liability, as we just discussed before, is really the general practice. Here you would find a licensor established somewhere in Ireland and simply disclaiming everything. Here the invalidity of the disclaimer, as I said, only a problem when they're not in Ireland. In the B2C context, as we saw before, all damages I cannot disclaim. A certain level remains. However, in practice, what are the kind of damages that a consumer suffers if software has vulnerabilities? What real damage happens to a consumer? They lose maybe some of their data. What data? Photos? Baby photos? Vacation photos? Yes, that is a harm, but it's an immaterial harm. If all photos of my baby girl got lost, this would be a huge, this would hurt. But it would not hurt financially. It would hurt in my heart. And the pain I feel in my heart is not recoverable under most legal regimes, in particular in Austria. There is no way for a consumer to get immaterial damages because they lost their most favorite photos. That means in practice that even though we have a statutory liability regime vis-à-vis consumers, the amount of damages that they'll be able to claim is rather limited. And from a software developer's perspective, the risk of providing software to consumers is therefore not as great as it might seem. So real financial damage being suffered by a consumer, rather unlikely. It would have been cases like he had stored his CV and job application on the system, and the day before the interview, the software ate his CV, and therefore he couldn't successfully go through the application process, didn't get the job, and now is not earning the money that he would otherwise have earned. Okay, but come on, that doesn't happen in the real world that often. For custom software development, the practice is simply that you will not be able to get what you want. You will have to negotiate a contract. You might have a stronger negotiation power than your customer, if you're lucky, but it will never be full negotiation power. You will have to give your customer something. So a full disclaimer is rarely possible. So who is responsible for what kind of vulnerabilities? Specifically, when you're looking at custom software developments, is something that we should regulate a bit more specifically in the agreement, because you might have cases where the customer is telling you to implement certain features, deactivate certain security settings, etc. And you're thinking, well, maybe that's not such a great idea, but oh, come on, if he tells me to, of course I'm going to do it. Who is liable at the end of the day if the customer is instructing you to do something that from a security perspective is a bad idea? Ideally, you have something set out in the contract that clearly says what kind of process applies here. Under Austrian law, but that's just Austrian contract law, the general rule is that you're the expert and you have to warn them if you think that an instruction you receive from them is ultimately hurting the quality of the product. So the default position of the law is that it's on you as the developer. Changing that default position might be valuable. So if possible, from a developer's perspective, I always try to negotiate into the contract that this specific provision under the law does not apply, so that you're not required to warn if an instruction is bad. Simply the argument would be, well, the customer has an own IT department, etc. They should know better than giving such an instruction. Why should we be liable for it? One other aspect that increasingly pops up is in custom development projects, you have many pieces that are not being developed by you. You're including third-party software, open source software. What kind of liability do I have when I ship a product consisting of, I don't know, let's say 50,000 lines of codes of myself, and the rest, 500,000 lines of code, are third-party open source software? What kind of liability do I have for that? Ideally, it says so in the contract, because if you have nothing else written in the contract, you have a rather broad liability, irrespective of the fact that this is third-party software, that is industry standard, whatever. If you have promised to deliver product X with these features, and to implement these features, you are using third-party software products, nonetheless, it's your overall product. You remain fully responsible for the entire thing. So simply saying, yeah, sure, it's a severe vulnerability in there, but come on, millions of people have now to face this vulnerability because it's commonly used open source software, is not getting you off the hook. So ideally, you have a process in place that makes sure that the customer is ideally authorizing the use of certain third-party software products in your product, and you're, in effect, shifting responsibility to the customer. That would be, from the developer's perspective, that would be the ideal process. Now let's briefly look at the software as a service setting. Software as a service, as we all know, means that we have a very different business model, a very different technical setup. If we're shipping a software application, things are fairly easy in the sense that the application is running with the customer, the data rests with the customer. We don't have any access to the data, we just ship the software and the rest is with the customer. Creates certain challenges when it comes to updating the software, etc., maintenance issues, but basically it's all on the customer side. Software as a service means the software doesn't get shipped anywhere, it stays with us. Plus, and that from a legal perspective is the most significant difference, so does the data. The data doesn't rest anymore with the customer, it's with us. We hold the customer's data. And from a data protection perspective, that means that we are now subject not only to liability as a software vendor, but we're subject to liability under the GDPR typically as a data processor. We have certain statutory liability that to some extent we might be able to disclaim vis-a-vis our customer, but will not be able to disclaim vis-a-vis the end users, the data subjects, the individuals whose data we're actually holding in our system. That is statutory liability we cannot get rid of, and simply something we have to factor in since we cannot solve it with a contract that easily. Vis-a-vis the customer, our liability under the GDPR, we can manage to some extent. Otherwise, the rules for providing the software as a service are with the new EU directive on digital goods and services are for the first time actually identical to the rules that apply if we were shipping an actual piece of software. It used to be that for a service, we practically didn't have any liability. There was no implied warranty of any kind. With the new EU directive, that is changing. So if we don't put anything into the agreement, we have a certain level of quality, the usual level of quality we would be held liable for. So again, put something into your agreements if you want to avoid liability. And the very last thing I want to just in 1 minute talk about is liability issues in the context of a litigation. If you really have to defend yourself in a civil litigation, there are a couple of practical considerations. First, time. A litigation takes a lot of time. From a developer's perspective, the defendant's perspective, this is good. You want this to play out over a long time. As the plaintiff, the customer, time is typically what you don't have. You want a quick solution. So litigation for a customer to begin with is not very attractive. Secondly, being able to prove what you know. You might be very certain the customer instructed you to do something and it's all the customer's fault, but can you prove it? Do you have proper documentation in place for the entire software development project? In most cases, at least my clients, unfortunately don't, making things a bit difficult. So here the recommendation simply would be document what you do in order to then be able to defend yourself in a litigation. And lastly, complexity. Complexity hurts in any litigation simply because nobody will understand what we're actually talking about. A judge is not interested in the technical details of software vulnerability management. They're not. They want to get this case done and issue a verdict and move on. That's what they want. So the real practical challenge is dumbing it down, making it understandable for a layperson in a way that they can say, oh yeah, I get what was the issue here, what happened here, and that's why the developer is not at fault. Of course, dumbing it down is a huge challenge because, as we all know, this is not as a straightforward issue. Try to explain a buffer overflow to a judge. That's not an easy task. So being able to break things down, interpret them in a way that the judge will understand them, that's the first challenge. Otherwise, the default position for most judges, if they hear security hacking, etc., will say, oh yeah, this sounds like a very dangerous thing that happened here. and it will be the developer's fault. So making things understandable to the judge and an expert witness, if there is one of the significant challenges we have in any litigation. But hopefully, you don't get there, because you have managed all the risks proactively, either through secure coding practices or smart contracts that simply disclaim the liabilities that you would otherwise have. So either a legal solution or a technical one will help you to ever avoid a litigation. Thank you so much. If there are any questions,
tons of questions.
We have plenty of time.
So there was a lot of interaction. Thank you. There was a lot of interaction on Slido on this talk, so we have lots of questions for you. We will use the time wisely. I'll start off with the first one. Are there any insurances that cover security breaches on Linux servers? The first question insurances ask us is if we have an antivirus software installed.
Yes, there are security products in the market out there. And I've advised security companies as well as companies seeking insurance on such matters. Frankly speaking, the problem is that the insurance company will require you to implement so many security measures that the remaining risk that you have is so small that it might not be worth insuring in the first place. On the other hand, for an insurance company, very worth insuring. So, yes, it's possible to buy insurance for that kind of stuff, but from a business perspective, I'm not sure it's a wise investment.
The next question is about the liability in using open source libraries in own applications. I think you touched it in your talk, but maybe you have a few more words about this.
Practically speaking, my primary recommendation would be look at the security history of the library. How many vulnerabilities were there? How severe were there? And make sure you're subscribing to their announced mailing list if you're not otherwise receiving updates on it. But if it's a, let's say, industry standard, more or less commonly used in the industry, I would not have a problem using it as long as you're disclosing the use of the software to the customer. And in a custom software development project, I would do the disclosure as early as possible.
The next question is US specific. So the Trump administration wants to force big tech companies to put backdoors in their products. How liable is the US government for such a decision?
Not at all. States have full immunity in courts of other states. So, no avenue of redress here. Sorry.
So the next question, any recent Austrian court decisions on how vulnerabilities are factored in a judgment, unknown vs. known vulnerabilities?
No, no recent, well, to begin with, only the Supreme Court judgments get published in Austria. But there is, as a matter of fact, very, very little litigation in the software security space. The last case I handled before the Austrian Supreme Court basically concerned the question of whether a system that contained a backdoor where if you knew the URL you could access the entire database was secure enough. Austrian Supreme Court said, yeah, it was clear they wanted to protect it good enough. What you gonna do?
Good sign for us. Next question, who is responsible for if a rogue employee puts in a backdoor without the company's knowledge?
Company remains liable. Company remains liable for anything that the people that a company uses to fulfill the contract do, whether it knew about it or not.
So also, are managers personally liable if horrible, insecure software development processes are in place and managers simply accept the status quo?
Yes, but only vis-a-vis the company. If the company is sued for damages and accordingly has to pay quite a bit of money, that money the company can then claim from the manager, take redress. Yes, that's possible.
What is the threshold between agreed backdoor and documented service access? Many vendors ship insecure remote maintenance mechanisms that you could call a backdoor.
Well, anything other than, or at least equally secure as, maybe you have another idea, than storing the public key on the system and you using the private key to authenticate yourself for the maintenance access, I would take issue with. Any kind of hard-coded password, no, forget about it.
Makes sense.
New vulnerabilities are discovered every day. Any recommendations on how to handle such maintenance requirements? For example, maximum time to fix vulnerabilities.
Ideally, you have a very favorable provision in your contract, not only giving you enough time to do it, but also giving you additional remuneration for fixing it. If you really have to act quickly, there are cases where customers are demanding certain vulnerabilities to be fixed within 10 hours. That's hard to do. Make sure the size of your organization is appropriate and you have processes in place and we're able to fulfill that. If you're a 10-person software developing company, well, a 10-hour time frame will simply not be doable for you. So be realistic with your customers, I'd say.
Just to let you know, Lukas, we could go on like this forever. There's, I don't know how many questions, but we'll just go on a couple of minutes because I think you're all very interested in this topic. The next question would be, as an Austrian citizen publishing an open source software which violates US patent, trademark, copyright, what can happen to me?
As long as you're not vacationing in the US, nothing.
So you better stay here.
No, seriously, don't go on vacation there if you're infringing US patents. Don't.
So staying here would be safe.
Yeah.
And then we have a question, so maybe somebody is looking for a new job. Are security experts in demand at large law firms such as Baker McKenzie? And what could a typical career look like without a law background?
Frankly, we're not quite there yet as a professional service firm that we are as a global firm to be employing full-time security experts in our client work. We, of course, do have an entire information security department, our data center servers are ISO 27001 certified, and we have plenty of security experts dealing with all that, but that's managed out of our Chicago office. And in the client work, as I said, we're not quite there yet. Give it another 5 years and we'll talk about it.
There's something that looks like a question, but it's not. I think it sums up very well in this talk. Awesome talk. Thank you, it says here. Thank you, Lukas, very much for this talk. Very insightful. Thank you for being here.
Thank you.
Thank you so much for having me.